It is a rematch of last year's AMTA National Championship Tournament, our 33 national final, with the University of Virginia facing Yale University. Along with two-time AMTA All-American Ian Lampert, I'm Jonathan Woodward, the TAB Director of the American Mock Trial Association, and we want to welcome all of you across the country and around the world to the live stream of our 33rd championship final. And Ian, it's not often that we get rematches of championships. We have teams that repeat, but to see an actual rematch, this is the first time this has happened since Virginia and Harvard back in 2007. It's going to be an exciting evening.
Definitely it will be. And one thing that I'm really interested in is who's actually returning from that final round last year. I'm looking here at Yale's roster, and it seems like the only returner is Sarah Cohen. Sarah Cohen, who was the middle attorney in the last two final rounds, is going to be a witness in this year's final round, meaning that perhaps the most versatile competitor in the history of AMTA, the only competitor to make 3 final rounds consecutively, is totally changing gears for this last final.
Right. And Yale isn't the only team to have a returner. My understanding is that the University of Virginia has 3 competitors who are returning from last year's final.
Who are they?
It looks like we have Dennis Tinchelli, who is going to be portraying Devin Harris, one of the witnesses. Also, Frankie Piacenti will be playing Jordan Rosenthal, and his sister, Alexandria Piacenti, will be the closing attorney this round. So we've got folks who were in last year's final, folks who were in the final in Cincinnati, folks who were in the final in Greenville. So it's going to be an interesting weekend, interesting evening.
Here's something I'm interested in. In this case, what side seems to have had an advantage throughout the preliminary rounds? I know that in this case, it's the first time that it's ever been tried, because AMTA changes the case now after all the preliminary competitions, specifically for the national championship trial.
And that's something is a challenge and was frankly a concern in deciding whether to go to a championship case. Is one of the things that AMTA does very well throughout the competitive season is making sure that we have a balanced case product. And one of the arguments against going to a championship case was, how are you going to be able to make sure that at the championship you have a balanced case product? And there's lots of different things that the case writers can do to try to ensure a balanced case. And it was, I would say, a reasonably balanced case, at least in one of the 2 divisions. I think in both of the divisions, it was about a 56% plaintiff win percentage. So it was interesting. Yale actually ended up winning the coin flip for this round, and they chose to represent the defendant, going against sort of how the plaintiff was performing in the trial. But certainly these are 2 teams that didn't have really any difficulty on either side of the case during the weekend, which is usually the case at a championship. Looking at how Yale University did this weekend in their 2 defense rounds, they lost 1 ballot out of 6. 5 defense wins. They swept against UC Berkeley in round 2 by 15, 17, and 17. So
huge margins.
Yeah, certainly not a terribly close round in the eyes of those 3 scoring judges. And then in the determinative 4th round that actually ended up deciding who would compete here, you had Yale University going into round 4 at 7 wins. Georgia Tech was going into that round as the top team with 8 wins. But in that last round 4, Yale on the defense took 2 ballots by 15 and by 11 points. And Georgia Tech took one of those ballots by 3 points. So that 3-point loss to Georgia Tech, Yale's only loss on the defense this weekend. So you can see why they're feeling pretty confident about the defense coming into this round. Tell us a little bit about how Virginia did during the first 4 rounds this weekend.
Well, let's see. Virginia is on the plaintiff in this case. And their first plaintiff round, they swept against team 1486. So which team is that, 1486?
I believe 1486 is Duke University. That would have been Duke B, I believe.
So against Duke, and that's a national championship program.
Absolutely.
Back in 2012, Virginia was able to win by margins of 19, 12, and 12. And then in the determinative round against Rhodes' A team, they won by 7, they won by a point, and they lost by 9. 2-1 decision.
Right. And certainly that was a Rhodes College team that was coming into that round not having lost a ballot all weekend. They tied in round 1, but Rhodes College otherwise had swept up to that point. So those are two teams coming into the fourth round, both with a very strong chance at being the next national champion, and Virginia just prevailed in that round. As someone that has competed twice in a national final, once as a witness, my understanding was as a freshman back in 2011 in Des Moines in the Happy Land case, and then in your senior year as the closing attorney in Orlando in the Rock World case. Let's start with talking about as a witness. What does a witness have to do in a championship final that might be different than what you would do in another round?
It's all about audience appeal. In that national final round, you have to read the audience, and you have to gauge that kind of reaction, because subconsciously, or perhaps very consciously, those final round judges will respond to the energy of the crowd. I was privileged enough to be a character witness in my first national final round, so getting a few laugh lines in changed the flow of that round, I thought, certainly the flow of that cross-examination. But even if you're a sympathetic witness, if you're able to build up that necessary drama that has everybody on the edge of their seats, the judges will appreciate that too. And if you're an expert, I think you're allowed a little more leeway to be perhaps a touch snarkier. Something that the audience might like more, but in a small room would not read well. That's what I'd say. Okay. Audience appeal.
How much do you think that audience appeal interplays with the judges' reaction? I've seen championship finals where the room seems to be maybe a little bit more heavily weighted in terms of one of the two teams. One of the teams seems to have the funnier witnesses or has more audience appeal, but the judges don't always seem to be reacting the same way to that. How does a witness balance the audience appeal versus how the people actually determining the round seem to be feeling it?
I think they have to pick their battles. The important thing is to establish that they can be funny, that they can win over the crowd. Not that they're going to throw away all of their credibility, so they're continuously breaking character or doing things that their witness would not for the sake of a reaction.
Now, 4 years later, as an attorney, you had, in my opinion, a fantastic closing argument.
Thank you.
And that was a big room. That room where we had the championship final in 2014 in Orlando was the ceremonial courtroom at the Orange County Courthouse. It was like a two-story room, a big, tall, cavernous space where the sound really echoed. The room where the championship final is going to be this evening, you see it on your screen. It's much more intimate. It's a smaller space, more of a lecture-style seating type of courtroom, lower ceiling. How does that factor into what an attorney does to sort of own the courtroom space?
What I noticed at the start of this trial is that the attorneys were doing sound checks. And I think that's important because they don't want to be too loud for the space or too quiet. They might overcorrect because they know that it's a smaller space. At the end of the day, when it comes to attorney presentation, just like everything else in mock trial, it's a comparative game. It's points-based. So that means that if you can be just a little more charismatic, just a little louder than the competition, that might mean a point or two in the whole trial, and that point or two could be the difference in the outcome.
Another thing that I remember from that championship final in 2014, really many of the championship finals, the same with the one in Des Moines where you were a witness, the championship final last year in Greenville, they had much bigger wells than there are in this room. And so there was an opportunity for you or the other closers or even the witnesses when they're giving the opening statements to have a lot of purposeful movement. I don't know how much of that we're going to see this evening, only because there really isn't that much space in this well for the attorneys to move around. There's also a large sort of podium that would be used for electronic demonstratives, putting PowerPoints, things of that nature, sort of right smack dab in the middle of the well that may prevent the attorneys from doing some of that purposeful movement during openings and closings. So I'm going to be interested to see whether the attorneys decide to stay mostly stationary or whether they still try and make some use of that little bit of room they have in the well during openings and closings.
I think that they're likely to move from one counsel table to the other, perhaps stopping in the middle when they're going by point to point. I think that they're likely to also use that podium in the center if they have a demonstrative they want to put it around there. Also, if they're going to impeach, for example, they might place an affidavit down at that space so they don't have to run back to council table all the time.
Now, I did not have the chance to see either Yale University or Virginia this weekend, so I don't know what they have in terms of demonstratives. Obviously, last year, one of the more memorable moments in the Yale-Virginia round last year was Daniel Stern from Yale University doing the My Cousin Vinny cross-examination with the measuring tape going to the back of the room. This case may or may not lend itself to that type of thing. It's maybe more common in a criminal trial than a civil trial. But another thing I'll be interested to see is exactly what the two teams do with demonstratives or other sort of interesting things outside the normal sort of mock trial paradigm.
And I agree with you on that. And one thing that I think we should discuss is what's the general summary of this case for those who aren't familiar?
Sure. So the caption of the case is Taylor versus Trifecta Entertainment. Trifecta Entertainment, of course, a callback to our national championship case from 2010. That was a murder case involving an executive of Trifecta Entertainment. We brought back the company name, but this case really has nothing to do per se with the 2010 case, other than a person who is an employee of Trifecta Entertainment wrote a play. And the play had the audience voting at intermission, and in that play it was about a romantic relationship between a couple, and depending on how the audience voted, there were two different Act Twos, and the audience vote would decide who won. And that is something that Alex Taylor says that they wrote. It was their original work, and they got a copyright for it. Well, sure enough, after they were no longer employed by Trifecta, then all of a sudden Trifecta Entertainment comes up with their own play, where the audience votes at intermission, and at Act Two, there's a different Act Two based on the audience vote, but that play was based on a gubernatorial race between two candidates for governor of Midlands. So Alex Taylor, of course, says, hey, Trifecta, you stole my copyrighted work. Their claim is that another Trifecta employee actually sort of pilfered that off of their flash drive and that sort of thing. And Trifecta Entertainment has a various number of defense theories available to it. I think one of the common ones is, no, this is actually our original work first and you stole it from us. So that's another thing we'll be interested to see today is exactly what theory the University of Virginia is going to go with for their defense.
Looking at the witnesses that were called, the paradigm in many AMTA final rounds has been for either side to call a sympathetic witness, to call a funny or character witness, and to call an expert. Is that what we're seeing from Yale and UVA in this case?
It is. So the first witness we're going to be hearing from the plaintiff, which is University of Virginia, is going to be Alex Taylor, the plaintiff themselves. So we'd expect that they would characterize that as sort of the sympathetic plaintiff. But at the same time, unlike a criminal case, it's not necessarily, the quote-unquote grieving spouse. We're going to go down now to the courtroom. It looks like we're getting some announcements from Gonzalo Freixas.
Good afternoon. We are now going to go on the record in the matter of Alex Taylor versus Trifecta Entertainment. Counsel, are you ready to proceed?
The plaintiff is ready to begin.
The defense is ready to begin.
All right, then you may proceed.
Your Honor, before we begin with opening statements, we do have a few pre-trial matters. May we start by introducing ourselves?
Please.
Good afternoon. My name is Alexandria Piacenti. I'm here today with Casey Schmidt.
Afternoon, Your Honor.
And Sabrina Crombie.
Good afternoon, Your Honor.
Together we represent the plaintiff, Miss Alex Taylor.
Good afternoon, Your Honor.
Good afternoon.
If the defense may make introductions.
Please.
Good afternoon, Your Honor. My name is Andy Parker. I'm here with my colleagues, Miss Elizabeth Bays.
Good afternoon, Your Honor.
And Mr. Michael Burns.
Good afternoon, Your Honor.
We represent the defendant in today's case, Trifecta Entertainment, and we're joined by the Chief Creative Officer of Trifecta, Ms. Matt Garcia.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, I have a few documents for your reference. The complaint, available law, and the stipulations. I've already shown opposing counsel. May I approach and tender to the bench?
You may. Thank you.
Lastly, Your Honor, we'd like to invoke Rule 615, constructively sequestering all witnesses except for party representatives. Ours, of course, will be Miss Taylor.
Any objection?
No objections. Ms. Garcia will be our party representative.
All right, thank you. That's granted.
Yes, Your Honor, and with that, the plaintiff is ready to begin.
All right, why don't you proceed with your opening statement?
Excuse me, Your Honor, before the plaintiff begins, we just have a couple documents we'd also like to tender to the bench.
I'm happy to take them.
It's the answer to the plaintiff's complaint in the Midlands Rules of Evidence.
Thank you.
Permission to approach?
Please. All right, any further pretrial matters before we proceed?
Nothing from the defense.
None from us either, Your Honor.
All right, you may proceed.
Opening statement, Your Honor.
Yes.
Follow the script. Members of the jury, this woman's name is Alex Taylor. She's a writer. And about 4 years ago, Miss Taylor wrote a script for a play called The Argument. She got it copyrighted. But today you'll learn that someone stole Miss Taylor's script and used it without her permission. Today we'll prove the company who did that was the defendant, Trifecta Entertainment. And we'll prove it by asking you to follow the script. You see, members of the jury, today you're going to learn that the summer after Miss Taylor wrote the script for The Argument, she interned for the defendant company. So did her roommate, someone named Jessie Parks. And you'll hear that after Miss Taylor wrote her script and got it copyrighted, she and her roommate found out that only one of them would be getting the job at Trifecta after the internship ended. So today we'll prove how Jessie Parks, that roommate, stole Miss Taylor's script and the job. You'll learn that Jessie Parks logged on to Alex Taylor's computer and copied her script onto a flash drive. Miss Parks changed some of the words, but not the most important ones. And you'll hear that after Jessie Parks and the defendant used Alex Taylor's words to create a different play, Jessie Parks left that same flash drive in a cab, with Miss Taylor's script still on it. And that's why Alex Taylor is suing Trifecta Entertainment for copyright infringement. Now, as the plaintiff, we have the burden of proof today. But some of what we have to prove is undisputed. You'll see that everyone here agrees that Miss Taylor wrote a script. And we all agree that Miss Taylor has a valid copyright for that script. So because of that, we just have to prove to you that Trifecta Entertainment had access to Alex Taylor's script. And that the two scripts in today's case, Miss Taylor's and Trifecta's, were substantially similar. Now, as the judge will tell you, substantial similarity doesn't mean we have to prove Trifecta took all of Miss Taylor's script, or even most of it. We just have to show you that the two scripts were similar, and that those similarities matter. That's exactly what we're going to do today. And we'll do it by asking you to follow the script. From the computer Miss Taylor used to write, to the copy Jessie Parks made of it, to the cab where that copy was found. So first, the computer. Today you're going to hear from Alex Taylor herself. She's going to take this stand and tell you how when she was living with Jessie Parks, she kept her script on her computer. Miss Taylor's going to explain how Jessie Parks asked to borrow that computer. On the same day, she found out Miss Taylor got a copyright for her script. Which will bring us to the copy Jessie Parks made of that script. You see, you're also going to hear from a professor who specializes in plagiarism. He's going to walk you through both of these scripts side by side. And when he does that, you'll see that the most important lines of the most important scenes of both plays use the exact same words. And that'll bring us to that final thing, the cab. You see, you're also going to hear from a cab driver who drove Jesse Parks and the defendant's creative director, Mac Garcia. And he's going to tell you how that ride happened months after Miss Taylor copyrighted her script, and months after the theft, long after the defendant thought they'd gotten away with it. But that cab driver will tell you that Jesse Parks left something behind. A flash drive. The same flash drive he used to steal Alex Taylor's script. Members of the jury, we're going to ask you to follow that script. From the computer to the copy. From the copy to the cab, and from the cab straight back to the defendant. That's why we'll ask you to find Trifecta Entertainment liable. Thank you.
Thank you very much.
Opening from the defense, Your Honor.
Please.
Thank you. May I proceed?
You may.
When Miss Grandi just came up here, she told you to follow the script. What she meant by the script was actually two different plays. The debate by Trifecta Entertainment and the argument by Alex Taylor. Today you're going to hear those plays. They had some similarities. In both plays, the first act centered around a disagreement between two people. At intermission, the audience got a chance to vote to decide who won. And then the second act diverged along different storylines based on how that vote went. Ms. Grandi says that the plaintiff is here because it had to have been copied. Members of the jury, we agree. It's strange that two different plays have the same type of conflict with the same intermission vote with the same diverging storylines. That could not have been a coincidence. One of these people stole this play. But it wasn't the defendant. Because, members of the jury, you can't steal your own idea. Now, to understand this case, we've got to go back to late 2012. It starts with a woman named Mac Garcia. She's the chief creative officer of Trifecta Entertainment, and she's here with us in court today. It's her job to come up with new ideas for studio productions. She thinks about how to make new plays. And in late 2012, a year before she ever met the plaintiff, Alex Taylor, Miss Garcia had a new idea for a play where the audience would get a chance to participate. She thought about how it would work, how it would influence the story, how the outcome of the play would change based on that new audience participation vote. And she wrote all those ideas down, and she put them in what's called her Great Ideas folder. It's just a manila folder, and it says Great Ideas in big capital letters on the front. It's where she keeps all of her ongoing work. And today we're going to show you that folder. You're going to see it, and you're going to learn about all the work that was inside. Today you'll hear that the plaintiff had access to Mac Garcia's folder on two separate occasions. That the plaintiff stole Mac Garcia's great ideas. Now, the first time was on April 14, 2013. You're going to learn that the plaintiff was left alone in Mac Garcia's office with Mac Garcia's folder just an arm's length away. Great ideas in big capital letters on the front, and all of Mac Garcia's outlined work inside. That was the first time that Alex Taylor had access to Mac Garcia's ideas. The second time was a month and a half later, on May 31st. This time we're at a barber shop. We're across the street from Trifecta. And Mac Garcia, she comes in, gets her hair cut, and she accidentally leaves behind her Great Ideas folder. The barber, who's going to testify later in the trial, will tell you how he found the folder and he gave it to the next Trifecta employee who came in, Alex Taylor, the plaintiff. But Alex Taylor didn't give that folder back to Mac on May 31st, or the next day, or the next day. Today you'll learn that Alex Taylor kept that folder for 3 full days before giving it back to Mac Garcia. And on the exact same day, you'll hear that Alex Taylor filed for copyright with a final, fully revised version of her play. A play which now had a vote, an alternate second act, and diverging storylines based on how that vote went. But now we're here in court with the plaintiff suing Trifecta Entertainment for copyright infringement. She wants you to believe that Jesse Parks or Mac Garcia or someone at Trifecta Entertainment stole her idea. But members of the jury, you can't steal your own idea. And this was Mac Garcia's idea. The plaintiff in today's case has the burden of proof, meaning it's their job to show you that their side is more likely than ours. The problem is, members of the jury, that the law says that if at the end of this trial you believe that the plaintiff was the one who stole this idea, that Trifecta was the one who came up with it first, and that is the reason why these two plays are so similar, then the defense is not liable for copyright infringement. And today, multiple witnesses will tell you that Mac Garcia had this idea long before ever meeting Alex Taylor. That's why my co-counsel, Ms. Bays, will come before you at the end of the trial and ask you to find in favor of the defense. Because, members of the jury, you can't steal your own idea. Thank you.
Thank you. Plaintiff, are you ready to call your first witness?
We are, but before we do, Your Honor, we'd like to offer into evidence Exhibit 1, Ms. Taylor's certification of her copyright. Pursuant to stipulation number 2, both parties have waived any and all objections to the admission of this document. May I approach opposing counsel and tender a copy to the bench?
Please. Thank you.
With that, Your Honor, the plaintiff calls Alex Taylor to the stand.
Ms. Taylor.
Could you please introduce yourself to the members of the jury?
Good afternoon. My name is Alex Taylor.
Where are you from, Miss Taylor?
I grew up in Bell Buckle, Tennessee. It's real small, just about 500 people. But I'm living right here in Midlands now.
How'd you end up here in Midlands?
Well, I actually came here for school. I always wanted to study playwriting, and the University of Midlands has got the best writing program there is.
Why do you want to write plays?
When I was about 9 years old, my mama took me to see this play called A Raisin in the Sun. It's about this black family living in Chicago back in the 50s. And I was just blown away. And when I found out that the lady who wrote the play was the first black woman to have her play on Broadway, I knew exactly what I wanted to do with my life.
Miss Taylor, I want to talk about a play you wrote. What was the name of the last play you wrote?
It was called The Argument.
When did you write it?
During my junior year of college. I finished it before I started interning at Trifecta Entertainment.
How'd you come up with the idea for your play?
The same way I come up with all my ideas. Something happened to me in my life, and writing the play was my way of getting through it.
What had happened to you?
Well, I was dating this guy, Tracy. Tracy Clark. We were crazy in love, and everything was going great. But then one day I come home and Tracy's packing up his stuff. We get into this huge fight. I'm trying to convince him to stay. He's telling me why he's got to leave, and by the end of the night, Tracy was gone.
Miss Taylor, how'd you turn that experience into your play?
Well, the whole play was about the argument that Tracy and I had. But when I first started writing it, I realized the audience would need some background. So I put in some flashbacks to tell the audience what they need to know.
How'd it end?
That was the hardest part. I spent weeks trying to figure out whether I should have Tracy's character come back or whether my character should just realize that she's better off without him. After a while, I figured I didn't have to make the choice myself.
What do you mean?
Well, I decided to let the audience choose the ending. Act 1 would be the same every night. But then right before intermission, the audience would vote for who won the argument, whether the couple stayed together or split apart. And then Act 2 would be completely different, depending on how the audience voted.
Miss Taylor, at that point in your life, how many plays would you say you'd read?
Hundreds, probably.
And of those hundreds of plays, how many let the audience vote in the middle of the show?
None. That's why it took me so long to come up with it. I hadn't seen anything like it anywhere. I had to convince myself it was even something worth trying.
So, Miss Taylor, how'd you make your idea work?
Well, after toying around with a few different ideas, I decided to have one of the characters give a monologue at the beginning of Act 2. This would tell the audience how the vote turned out and where the play was headed from there.
Your Honor, let the record reflect that approaching opposing counsel, what's been pre-marked for identification as Exhibits 12A and B. May I approach the witness with the same?
Yes,
Would Your Honor like copies?
I have copies, thank you.
Yes, Your Honor. So, Miss Taylor, what have I just handed you?
These are the monologues from my play. One for my character, Aaron, and one for Tracy's, Donnie.
So why are there two different monologues?
Well, because Act 2 would be different depending on who the audience voted for, and the easiest way to make that work was to write two different monologues, one for each character.
Do these monologues look the same as when you finished writing them?
Yes, ma'am, from what I can tell. Even Aaron's monologue still has the typo I forgot to edit out.
Your Honor, we offer Exhibits 12A and B into evidence. Pursuant to Stipulation 5, both parties have waived all objections to the admission of these documents.
That's our understanding as well, Your Honor.
Thank you. They're admitted.
So, Miss Taylor, when did you finish writing your play?
That was in April of 2013. I actually wrote the monologues last because they were the most important part of my play.
What'd you do after you finished writing those monologues?
Nothing. I didn't do anything with it.
Why not?
It was just so personal. I mean, this was my life. I had these characters saying things that I had said to Tracy and things that Tracy had said back to me. Writing it down was one thing, but showing it to people, having an audience watch it on stage, I wasn't ready.
Miss Taylor, I want to talk about how we ended up here today. When did you first learn about Trifecta's play?
The day after it opened, in January of 2016.
What happened?
Well, I was sitting at my desk, drinking coffee and reading theater reviews like I always do. And I came across this review for a play produced by Trifecta.
What play was that?
It was called The Debate. And the more I learned about it, the more familiar it sounded.
What do you mean?
Well, some of the details were different, but the play was still about two people having an argument, with flashbacks, and then the audience voted. And then I saw who the author was.
Who was it?
Objection, Your Honor. Hearsay as to the last portion of the witness's statement. May I be heard?
Certainly.
Your Honor, we have a good faith basis to believe that she actually heard this from a theater review which she said she was reading, and that's why she knows it. Now, to introduce these as the key elements of the play would be hearsay. They're offering it for the truth, that those were the important parts of the play, that that's what the play was about. Now, at contention in today's case is what exactly the most crucial elements of the play were. And therefore, to have her testify to someone else's opinion as to what the important elements were is inappropriate and hearsay.
May I respond, Your Honor?
You may.
All Miss Taylor said was she found out who the author of the play was. First of all, that's not hearsay because there's no statement being offered. Miss Taylor's simply talking about her own knowledge. We're not talking at all about parts of the play or their importance. She's just saying who she found out who the author was.
Objection is overruled.
Miss Taylor, who was that author?
It was Jesse Parks, my old roommate.
When did you live with Jesse Parks?
That was in the summer of 2013, back when we were both interning at Trifecta Entertainment. It was the summer after I finished writing the argument.
Miss Taylor, I want to talk about whether Jesse Parks might have ever seen your play. Where were you storing your play that summer?
On my computer, my laptop.
Could you tell the members of the jury if you ever saw Jesse with your computer?
Yes, ma'am. It was in July of that summer, just a couple days after Trifecta told us that only one of us was going to get the job at the end of the summer.
So what happened?
Well, Jessie comes into my room and she's holding this flash drive. And then she asks to borrow my laptop.
Before that day, had Jesse Parks ever asked to borrow your laptop?
No, ma'am. Not from what I can remember.
After that day, did Jesse Parks ever ask to borrow your laptop again?
No. That was the only time that summer that Jessie asked to borrow my laptop.
So that one time Jesse Parks asked to borrow your laptop, how long did she have it for?
All night. I gave it to her that evening and I didn't see it again until the next morning.
Miss Taylor, when Jesse borrowed your laptop, do you remember where on your computer your script was saved?
Yes, ma'am. It was saved right on my desktop. It was the only Word document I had saved there.
Miss Taylor, if your script was on your computer, why'd you let Jesse Parks borrow it?
Because Jessie was my friend. I mean, we went to school together. We worked together. We even lived together. I trusted Jessie.
Thank you, Miss Taylor. Nothing further, Your Honor.
Thank you. If you could hang on just a moment.
Your Honor, while you converse with your co-judge, would you mind if I set up the court for use of a demonstration?
Please go ahead and do that. Thank you.
Your Honor, before Ms. Bays begins, may I ask when she uses that demonstrative if I may move to see it?
You're asking me?
Yes, is that all right, Your Honor?
It's absolutely all right.
Thank you, Your Honor.
I thought you were asking her.
You, Your Honor, thank you.
Thank you. You may proceed.
And before I proceed, is this visible to everybody, or should I turn it more so that everybody can see it?
I think we're good.
All right. Good afternoon, Miss Taylor.
Good afternoon.
The truth is, even before you heard about these plays, you weren't the biggest fan of Trifecta Entertainment, were you?
That's not true at all.
Well, Miss Taylor, when you first took the job at Trifecta, you expected it to be a full-time, right?
Are you talking about the internship?
That's right. You expected that internship to turn into a full-time job, right?
Well, sure, all of us did.
And-
Usually when Trifecta had interns, it would turn into full-time job employment afterwards.
You were pretty excited about that, right?
Well, sure.
You had dreamed of becoming a playwright, right?
That's right.
You wanted to be the playwright who made the new production that would put Trifecta back on the map, right?
Well, sure, you could say that.
But about middle of the summer, Trifecta actually threw a wrench into your plans, didn't they?
I think you're referring to when they told us that only one of the interns would get the job.
That's right. They told you only one person out of 20 would be getting the job, right?
That's right.
You'd say you were absolutely shocked.
Well, sure, at the beginning of the internship, they said all of us would be hired, so we were all real surprised about it.
And then you found out that Jessie would be getting the job instead of you, right?
That's right. Jessie did get the job.
You thought your work was pretty good.
Sure, I mean, I think pretty highly of myself, I guess.
You didn't understand why Jessie was getting the job instead of you.
No, I wouldn't say that.
You wouldn't say you didn't understand why you didn't get the job?
No, I would say I was a little confused at first, but I was happy for Jessie. Jessie was my friend.
So you were a little confused, and then a year later, you find out that that Jesse Parks has produced a play, right?
Not exactly. The play didn't come out until January of 2016.
Right, so January of 2016, you find out that Jesse Parks has produced a play, right?
That's right.
And you find out that that play is winning dozens of awards, right?
That's true.
That play is putting Trifecta back on the map just like you'd want it to.
Well, sure, I guess you could say that, but I wasn't upset that Trifecta was being successful. I was upset because Jesse took my ideas.
Well, ma'am, I'm not asking about Jesse taking your ideas. We'll get there in a minute. I'm just asking if Jesse's play was putting Trifecta back on the map, and that's what you read, right?
I read that it was doing very well.
So just a few minutes later, after only reading 2 paragraphs of the review, you decided it must be copying, right?
Well, sure, because what I read was talking about the voting, the audience participation, the alternate endings. It sounded just like my play.
Well, let's talk a little bit about copying, Miss Taylor. We've heard today a lot about Jesse having access to your computer. But the truth is, you had access to some of Trifecta's work, right?
I'm not sure what you mean.
Well, you do remember that when you started writing your play, at first it was just a simple play about human emotions, right?
When I first came up with the idea, I knew it was going to focus on a breakup. So the plot line was pretty simple, short.
That's right, and you were starting to wonder what you should do, what ending you should put in, as you said on Direct.
That's right.
But April 14th, you actually had an interview with Trifecta Entertainment, right?
Yeah, I did interview with them that day, you're right.
And during that interview, you actually noticed a folder on Matt Garcia's desk, right?
Sure, it is her Great Ideas folder.
That's right, and just to be clear, Matt Garcia, she's the head of Trifecta Entertainment's creative division, right?
She is.
Miss Taylor, you recognize this as the folder you saw on the desk, right?
Yes, ma'am.
Your Honor, at this time, we ask that Exhibit 3, the Great Ideas folder, be entered into evidence.
Any objection?
No objections, Your Honor.
It's admitted.
Miss Taylor, you see this folder sitting on the desk, and just a few minutes later, Matt Garcia walks out of the room.
Well, actually, I think Miss Garcia and Devin Harris, who were interviewing me, they had to leave to go get some evaluation forms.
That's right, so they leave the room.
They do.
And less than a month later, you have your first final draft of the play, right?
I finished the play the end of April 2013. That's
the
right.
end of April. That's after April 14th when you saw this folder, right?
Yes, ma'am, that's true.
And then a few months later, you see this folder again, right?
Right, Mr. Anderson, he's everyone's hairdresser. He gave me the Great Ideas folder to give back to Miss Garcia when she left it.
Right, so you walk into a hair salon and you see the folder under a chair, right?
No, actually, it was Mr. Anderson who found the folder and then gave it to me.
And he gives the folder to you, right?
That's right.
Says, take this back to Matt.
He did.
You don't take it back that day, right?
Well, ma'am, I couldn't. See, when Mr. Anderson gave me that folder, it was a Friday. The office was closed. So I gave it back to Miss Garcia first thing Monday morning.
Sure, you gave it back on Monday rather than Friday, right?
That's correct.
Which means you had the folder in your possession for 3 full days, right?
Well, sure, it was in my work bag until I gave it back.
And the last day of those 3 days, that's June 3rd, right?
I got the folder in May 31st, so yes, June 3rd.
June 3rd, that's the same day you submitted your final copyrighted edition, right?
That's when I filed the application. That's true.
And after you get copyright, you actually went to some lengths to keep this play away from Matt Garcia, didn't you?
No, ma'am.
You wouldn't say you did?
I'm just not sure what you're talking about.
Well, after you got your copyright, you were pretty excited, weren't you?
Well, sure, I was proud of what I'd done.
Right, so you started texting your friends, right?
Yeah, I talked to a couple of friends about the play. That's
Told
true.
them all about this new structure for the play you had?
I don't remember exactly how much detail I went into, but I sure mentioned it. That's true.
Told them all about the audience vote, right?
Yep, the audience vote, the alternate endings, about the couple, everything.
Even let them read the play.
I did for one of my friends, yes.
But your friends at Trifecta Entertainment, they were a bit of a different story.
Well, which friends are you talking about?
Well, Jessie Park, she was a friend of yours at Trifecta Entertainment, right?
Well, not after he graduated, no.
But during that internship, she was a friend of yours, right?
Oh, yeah, sure. We were still friends then.
In fact, you'd call her an old friend.
I would.
Didn't show her the play.
No, I didn't show her.
Didn't tell her anything about the structure.
Not about the structure, but she knew that I had written the play.
You had another friend at Trifecta Entertainment called Devin Harris, right?
Yes.
Didn't tell Devin Harris about the structure of your play, right?
No, I didn't talk to Mr. Harris about it.
You knew Matt Garcia worked at Trifecta Entertainment, right?
Yes, she supervised us.
She was your supervisor, as you just said.
Yes, ma'am.
Now, ma'am, you thought this play was pretty good, didn't you?
I mean, I thought so.
You'd call it your golden ticket to getting a job.
Well, yeah, I figured that, once I got a full-time job as a playwright, I could share it with the company I was working for.
Ma'am, you didn't share your golden ticket with the woman who was supervising you and deciding whether you'd get a job.
Well, of course not. I wasn't offered the position at Trifecta.
But before you were offered the position, you knew that one of the interns would get the job, right?
That's what they told us.
And you didn't share your golden ticket with Matt Garcia.
No, ma'am, like I said, it was my plan to only share my play once I had the full-time job.
Well, let's talk about why else it might have been so important to keep this play away from Matt Garcia. Now, you told us on direct examination that your play had an argument in Act 1, right?
Yes, when the couple itself, they were arguing, and that's kind of where we had the flashbacks and kind of uncovered that whole bit.
It had a vote at intermission, right?
Yes, and it would decide how Act 2 went on.
It had 2 separate second acts, right?
Like I said.
And it had monologues at the beginning of those acts that set the tone for those acts, right?
Sure, and kind of let the audience know where things were going.
Your Honor, this time I'll be turning around the demonstrative. Now, you told us on direct examination that these were all your ideas, but the truth is you don't have any old drafts of your play from before May 31st, do you?
I didn't have any paper drafts of my play. Everything was on my laptop.
You don't have any notes about your play from before May 31st?
Ma'am, like I said, everything was on my laptop.
You don't have any digital evidence from your laptop of what your play looked like before May 31st?
What kind of digital evidence are you talking about?
Any digital evidence.
All I know is it was on my laptop, and I gave the script to you guys before trial.
So you didn't give us a dated copy of the script from before May 31st, right?
I don't believe it had a date on it. You're
So
right.
you don't have a dated copy of the script from before May 31st that shows that your play had an argument before May 31st.
Ma'am, that's when I wrote it and finished it in April of 2013.
But you don't have a dated copy that shows us that, do you?
I don't have any paper drafts with me.
Objection? Under Rule 403, Your Honor, both too argumentative and misstating the record. May I explain?
Yes.
At this point, for the record, Ms. Bays is standing next to a chart and she just drew a question mark on that board. Now, first of all, that's argumentative because it's essentially Ms. Bays testifying. Second, it's misstating the record because all that the witness was asked was if she has any drafts or notes. But Ms. Taylor testified just a few minutes ago that her play, Act 1, culminates in an argument. So to draw a question mark next to that, it's misstating what's already on the record.
May I be heard, Your Honor?
Yes.
Your Honor, in this case, she says this is the case, but she's already told us she has no digital evidence, no other evidence that this is the case. I'm not saying she doesn't, I'm simply saying she doesn't have any evidence. That's why it's a question mark, not say an X or something stronger.
May I respond, Your Honor?
Certainly.
In doing that, Ms. Bays is testifying. She drew a question mark and then just explained to you what that meant to her. The attorney's testifying, that's simply improper and it's confusing for the members of the jury.
All right, I'll let you clarify when you have an opportunity to question the witness.
Yes, Your Honor.
Ms. Taylor, you don't have a dated draft from before May 31st that has an audience vote at intermission.
Other than what was on my computer, you're right.
You don't have a dated draft from before May 31st where a vote determines what Act 2 you're going to have.
Sure, I don't have the printed copy that shows the vote or the contrasting emotional tones.
You don't have a dated draft or any notes from before May 31st that shows those monologues with contrasting emotional tones, do you?
Like I said.
But what we do know is that after you saw those great ideas folders 2 times, your play had every single one of those elements.
Ma'am, I didn't get any of my ideas from Miss Garcia's Great Ideas folder.
Ms. Taylor, that's not what I asked. I simply asked if your final copy, the one you had after you saw the Great Ideas folder, had every single one of those elements.
It absolutely did.
Thank you. Nothing further at this time.
Redirect.
Please.
Would you like me to deconstruct?
You can keep it up. ideas folder? How many days did you have that folder for after the hairdresser gave it to you?
Well, I had it over the weekend, so about 3 days.
Miss Taylor, how many words would you say are in your play?
Over 19,000.
How long did it take you to write those 19,000 words?
Ma'am, it took me months to do that.
Thank you. Nothing further.
Anything further?
Briefly, Your Honor. Miss Taylor, you just talked about the 3 full days when you had the great ideas folder, but the truth is that isn't the first time you saw it, right?
I did see it when I was interviewing because we were in Miss Garcia's office.
Right, you saw it on April 14th, right?
That's correct.
That is over a month before you submitted your final copyrighted edition, right?
Well, sure, but it was only a week before I actually finished the play.
It's over a month before you submitted your play, right?
Right, I submitted the application for the copyright on June 3rd.
Thank you. Nothing further.
Further redirect?
No redirect. May Miss Taylor step down?
You may. Thank you very much.
Thank you, Your Honor.
And Your Honor, permission to deconstruct?
Please. Do you wish to call your next witness?
Yes, Your Honor, but before we call our next witness to the stand, may we offer Exhibits 11A and 11B into evidence? Both parties have stipulated that these are accurate portions from Trifecta's play, The Debate, and have waived any and all objections to their admissions.
That's our understanding as well, Your Honor.
May I approach opposing counsel and tender?
Please.
Here you are, Your Honor.
Thank you. 11A and 11B are admitted.
With that, plaintiff calls Dr. Jordan Rosenthal. And Your Honor, as Dr. Rosenthal is taking the stand, may we set up some easels in the well?
Yes, you may.
And Your Honor, if I just may clarify for the remainder of today's trial, may attorneys move around the courtroom for viewing the demonstratives.
You may.
May we begin, Your Honor?
You may.
Could you please state your name for the record?
Jordan Rosenthal.
What do you do for a living, sir?
I'm a professor at the University of Midlands. I teach theater and creative writing.
How'd you come to be doing that?
When I was 15, my high school put on a production of Guys and Dolls. I didn't get a call back for guy number 5 or guy number 6. And by guy number 7, I figured the director felt bad for me. He asked me to write a review for the school paper instead. Luckily, that's when I learned I liked writing about theater even better than I liked being in it.
So, Doctor, how were you involved in today's case?
I was asked to perform a textual similarity analysis of 2 plays. Alex Taylor's The Argument and Trifecta Entertainment's The Debate.
What's the textual similarity analysis?
It's a quantitative and qualitative analysis of any 2 texts, where the goal is to determine just how similar those works actually are.
Well, Doctor, before we talk about your analysis, let's walk the members of the jury through your background.
Sure.
Where'd you go to school?
I studied theater and English at the Tisch School at NYU. I also received my master's in journalism and PhD in theater history from Columbia.
How long have you been teaching?
More than 2 decades now. I started at USC and moved over to U Midlands in 2008.
And what sorts of courses do you teach?
A little bit of everything, from basic script writing to comparative theater history.
Are you published, sir?
I am. I've reviewed hundreds of plays, both as a freelancer and for the Midlands Post. I've also authored over a dozen academic articles.
And Doctor, have you ever testified in court before?
I have, yes. This is my 5th time testifying as an expert witness, all of which involved intellectual property and the entertainment industry.
So then let's go back and talk about that textual similarity analysis you mentioned. Have you done things like that before?
Absolutely, in both the classroom and the courtroom.
How about with respect to theater?
Sure, 100%. I've done an analysis like this on multiple cases involving plays and theatrical works.
And do you use standard methods for that?
Of course, it's a basic analytical framework I've taught my students for years. We're mainly looking for 3 things: shared words, textual substitutions, and shared mistakes.
Doctor, have you been trained in identifying each of those things?
Of course.
And what information did you look at for this case?
Well, I reviewed the complete scripts of both plays, statements by their authors and Trifecta's creative director, as well as a number of other documents provided by Trifecta.
So then let's walk through your analysis. Where'd you start?
Well, this is a place where technology has made our lives a whole lot easier. We feed the entire text of both scripts into a computer, and the software checks for common words and phrases.
What'd you find?
Well, I've actually brought along a few enlargements from the original scripts so I could help walk the jury through my findings.
Your Honor, may Dr. Rosenthal step down to use these enlargements? The first things he'll be uncovering have already been entered into evidence as Exhibits 11B and 12B, and everything else has already been shown to opposing counsel.
Any objection?
No objections.
All right, you may approach.
Your Honor, we have smaller copies of these if you'd like as well.
Oh, that'd be great. Thank you
Of
very
course.
much.
Your Honor, may I approach with smaller copies of Exhibits 11B and 12B?
And 11B and, I'm sorry?
12B.
And
They've
those-
already been entered into evidence.
All right, and those are the 2 documents that are currently on the boards?
Yes, Your Honor.
Okay, yes, please.
Here are copies of 12B. And then here are copies of 11B.
Thank you.
Of course. So, Dr. Rosenthal, what are we looking at here?